Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-Immigration. Big news from e-Immigration. Their new intelligent form intakes just won a Legal Tech Breakthrough Award, and for good reason. This AI-powered feature lets clients complete and review intake questionnaires and forms in the language of their choice. Every form is automatically translated into 13 languages and then back into English. Attorneys get ready to file error-free packets in minutes. This means less back and forth and more confidence with every filing. Want to see how it works? Book your demo at geteimmigration.com or click on that special link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. So much news at the top of this episode. First off, Immigrants List has a bunch of new political advertisements. I've included links to them in the show notes. Spread them far and wide, in your community, in your family, everywhere internet connections are found. Continuing on in the news, the EB-5 rule was enjoined this week. The Trump administration is trying to bring back its draconian public charge rules. That's fun. There also appears to be a new third country agreement with Ecuador that allows the United States to transfer non-Ecuadorian citizens there so long as Ecuador will allow them to seek asylum, refugee protection, or equivalent temporary protection from their country of nationality or citizenship. So I believe taking away the rights of a bunch of people to seek asylum in America so they can go do so in Ecuador even if they never traveled through Ecuador. Crazy times. Also, DHS is now screening a person's social media to determine anti-Semitism when adjudicating any benefits. Moving right along, I've been asked to say this, and I am happy to do it. Happy early birthday to Professor Will Miller from Georgia State Law from your immigration clinic students. The students have written me, and they tell me that they appreciate your guidance in helping them produce the body of client-centered representation. I actually have come to know Professor Miller over the years, and am not surprised that he is beloved. Happy birthday, sir, and good luck at your upcoming important hearings and other matters. Finally, there were actually 8 decisions this week, 2 from the Sixth Circuit that I'm not doing, because Thanksgiving is right around the corner, and that is historically a slow week on the pod. And so, instead of giving you 8 cases this week, and potentially none next, I'm gonna save those 2 Sixth Circuit decisions for next week. I've also already got some news brewing for next week too. Always thinking. Here we go. Starting off with Ramos Marquez v. Bondi, published by the 4th Circuit on November 19th, 2025. What up, 4th Circuit? Thank you for giving me some non-citizen good this week. This case is about Convention Against Torture Protection and withholding of removal under the INA. Judge Wilkinson dissented. Mr. Ramos Marquez is from Honduras and fears the MS-13 criminal organization. Quote, the gang originated in Los Angeles, California in the 1980s. Since then it has spread across the country and into foreign countries such as El Salvador, Honduras, and Mexico. End quote. His brother was tortured and murdered by the gangs in 2014 or 2015. Police responded but never made an arrest. Several years later, another brother opened a produce shop, and Mr. Ramos Marquez worked with him at that shop. MS-13 extorted that brother too, telling him he knew what would happen to him if he didn't pay. Seems like they were referencing that first brother. He closed up and left town, and the gang began targeting Mr. Ramos Marquez himself. At first they were demanding information on the brother, and they demanded that Mr. Ramos Marquez begin working for them to pay off the made-up debt that they said the brother owed them. When Mr. Ramos Marquez refused, they beat him up pretty bad. He sought medical attention but did not report it to police. He moved in with his sister 30 minutes away and became a security guard. Got a gun. Different MS-13 members tried to get him to give up that gun. He refused. A few months later, members approached him and inquired why he kept refusing their demands. They brought up the brother again and threatened to kill Mr. Ramos Marquez. Well, technically they made him kneel on the ground and then put a gun to his head. Semantics. Then they hit him over the head with the gun and he lost consciousness. He didn't report this either, stayed indoors in fear for his life, and then fled to the United States. Kept getting Facebook threats while in the U.S. And then in 2021, MS-13 found the other brother in a different town and murdered him in front of that brother's wife. Police came and took a report, but didn't arrest anyone. Wild stuff. Also, MS-13 went to Mr. Ramos Marquez's sister's home looking for him and threatened him through her. An immigration judge in the BIA denied the claim. Seems like the asylum application is time-barred. Lots of primary and country condition evidence submitted, it seems, in support of withholding and cat protection. But the IJ didn't believe things were that bad in Honduras, and believed that the government was trying. The Honduran government, after all, even implemented a, quote, state of exception, end quote, to combat the gangs. Not unable or unwilling to protect, as required of withholding removal when you don't fear the government. Plus, despite this all happening in various cities in Honduras, and including 2 siblings being murdered, the IJ believed Mr. Ramos Marquez could reasonably relocate in Honduras. And the IJ didn't believe that all of this constituted past persecution. The IJ also didn't believe that this was bad enough for torture, believed that Mr. Ramos Marquez's fears were speculative, and didn't believe the Honduran government would acquiesce. All, of course, reasons to deny cat protection, if correct. The BIA affirmed for a variety of reasons, additionally dinging Mr. Ramos Marquez for not reporting what had happened to him to the police, as did the IJ, it appears. The Fourth Circuit majority disagreed. Can't ignore facts, explained the Fourth Circuit, and it believes that the agency did that here. Starting with withholding. Let's talk about whether the government is unable or unwilling to protect. In the Fourth Circuit, quote, evidence of empty or token assistance cannot serve as the basis of a finding that a foreign government is willing and able to protect, end quote. Indeed. What's more, quote, there is not a per se requirement that an applicant have reported his past persecution to police, end quote. Don't get me wrong, if you don't, you better have a good reason, or you're probably going to lose on unable or unwilling, explains the court, but still, there is no per se requirement. How do you make the showing to avoid a denial when you don't report? Well, you got to establish that, quote, 1, it would have been futile, or 2, have subjected the non-citizen to further abuse, end quote. Here, the IJ and the BIA believed it quite telling that police arrived at the brothers' murders and made reports. But that's not the winning fact the agency thinks it is, explains the Fourth Circuit. Particularly as in making the finding, the agency cherry-picked and ignored evidence. The evidence here shows that, quote, it is widely recognized that the Honduran government, including the police, military, and judicial system, is crippled by severe corruption. Lawlessness and impunity is widespread, end quote. Seems an important quote to remember. And ignored by the agency, said the Fourth Circuit. As to police showing up, though, empty actions to the court. And in any event, quote, it says nothing about whether the police would be able to control MS-13 before they murdered petitioner. They certainly were unable to control MS-13 before they murdered both of petitioner's brothers, end quote. All of it undiscussed, and so a remand's coming. What's more, the Fourth Circuit reads a record that quite clearly shows the Honduran government's inability and unwillingness to protect. The police officers' actions in both murders, showing up, taking reports, and doing nothing, shows that further reporting to police would be futile. Take note, y'all. Plus, Mr. Ramos Marquez's credible and unrebutted testimony explains what happens when the gangs learn that you file a report. So it's even worse than futile, quite dangerous to do it, supported by country condition evidence, if you guys are taking notes. As to the state of exception that resulted in some arrests of gang members, quote, "We note that purported government efforts to combat gang violence and corruption in general do not excuse the agency's failure to support its decision with the proper legal and factual analysis of petitioner's specific circumstances," end quote. Emphasis by the court. Moving on to relocation. After all, non-citizens need to show all of these elements. The government simply needs to win on one of them. Well, the Fourth Circuit doesn't think it likely that that is Mr. Ramos Marquez's burden, that is relocation, as it believes he likely established past persecution, meaning it would be DHS's burden on relocation. After all, the IJ and the BIA's no past persecution findings were based on the unable or unwilling to protect finding that the panel just vacated. Seems like this panel is actually saying past persecution was outright established. It also seems that the panel believes that DHS won't be able to establish reasonable relocation given everything that has happened. But of course, that's for the IJ and the BIA to determine on remand. As to Cat, and no burden shift with Cat either, even with a past torture finding. Still a remand, said the Fourth. In part, that's because the BIA only affirmed the Cat denial on a finding that the Honduran government would not acquiesce or consent to the torture of Mr. Ramos Marquez. The majority doesn't agree with that. Quote, "Petitioner's country condition evidence of Honduran acquiescence to torture was plentiful," end quote, and the BIA ignored it. Peek this decision for all the evidence the Fourth Circuit believes is very compelling on these issues to make your case about what the Honduran government does and does not protect against, and what it does and does not acquiesce or consent to, because it's all laid out in a couple of pages in this decision. Indeed, among many other things, the panel relays that the evidence shows that the Honduran gangs, quote, "negotiate with governmental representatives and operate in direct collusion with corrupt state officials," end quote. Heck, even the U.S. Department of Justice recently indicted a former Honduran president for similar stuff. None of it was addressed by the agency, and it's quite material to government acquiescence to gang torture, believes the Fourth Circuit majority. The BIA did this while all the while holding the evidence insufficient, yet not addressing the record evidence on point. The court sees potentially ends-oriented judging that was, at best, improperly selective of evidence that only supported a denial. Can't do that. So it's another very important Cat decision, and withholding of removal, of course, this time in the Fourth Circuit, to cite in that circuit every time DHS relies on the rash of recent anti-withholding and Cat BIA decisions coming our way. Circuit trumps BIA in every circuit, always. And here's a good one for the Fourth Circuit. Judge Wilkinson disagrees. But it's remanded in a big way, meaning congratulations, Madeline Nita Taylor-Diaz and Catherine Ann Soltis for petitioner. And that is Ramos Marquez v. Bondi. Hello, BIA. You gonna give me a nice Thanksgiving week with no BIA decisions? We'll see what happens. Because you got two this week. The first one being matter of KSH, published by the BIA. It's an asylum denial from the BIA. An immigration judge, too, for that matter. It's a Sikh-type claim from India. Mr. KSH appears to fear the BJP, political party, and or its affiliates. But really, this case is about the unable or unwilling to protect requirement, one that we just did a deep dive with in that Fourth Circuit case. Mr. KSH was attacked and threatened twice for his relationship with a Hindu woman, the sister of some of the attackers. Mr. KSH testified that when he attempted to report the first attack, police refused to do anything and actually threatened to detain him because the woman's father, and so I guess one of the attackers' fathers, was an influential member of the BJP political party. Quote, "The immigration judge acknowledged that a single police officer refused to take the respondent's report and cited his girlfriend's father's position in the BJP. However, the IJ found that the girlfriend's father had taken no part in the attacks, that there was no evidence that he had interfered with the police taking the respondent's report, and that the BJP was not an official part of the government at that time," end quote. It is now, though, I believe. Here, the BIA affirmed the IJ. The IJ was correct to hold against Mr. KSH that he only tried to report one attack, and that he stopped trying to report after that initial failure. Shouldn't have given up after the first scary and disheartening attempt to obtain police assistance, reasons the BIA. Plus, there was no showing that the father was actually involved in any of this. And that political party wasn't even in power in the time, so how can this show that the government was unable or unwilling to protect from private actor harm, as asylum requires? BJP wasn't in the government at the time. Reasons the BIA. Not citing to an unable or unwilling to protect decision, the BIA states, therefore, without legal citation, that, quote, overall, one local police officer's refusal to take a report because of concerns about a local BJP member does not establish that the government of India as a whole would be unable or unwilling to control the respondent's alleged persecutors, end quote. The BIA does, however, go through quite a few recent circuit, Sikh, India, and other cases, all discussed on the pod, or most discussed on the pod, reading them as additionally supporting a finding that a single incident where police won't help doesn't often suffice to satisfy the unable or unwilling to protect standard. Now, the BIA does recognize it as a problem, as this case arises in the Ninth Circuit. And in Davila v. Barr, the Ninth Circuit held that a non-citizen did indeed meet her burden, where she credibly testified that her, quote, abuser bribed the police officers she contacted and then beat her more severely in retaliation for her attempt to report. Her testimony that the police had been similarly non-responsive to her mother's reports of domestic violence, and country conditions evidence of the Nicaraguan government's indifference toward domestic abuse, end quote. Seems kind of similar to the evidence that we just described in that Fourth Circuit case. To the BIA, that's a lot more than what happened here and that was presented in this case. Here's how to make your case satisfy the Ninth Circuit standard according to the BIA. Quote, he faced no physical violence during or after his attempt to report his harm to the police, nor has the respondent even argued on appeal that any further attempts to report at a local or higher level of the government would be futile or dangerous, end quote. So show those things. Although I don't think either of those things was present in the Fourth Circuit decision that was just remanded on unable or unwilling to protect. By the way, in case you forgot, quote, the Ninth Circuit has held that an applicant is not required to establish that the government would be unable or unwilling to control persecution on a countrywide basis, and the inquiry is to the home, city, or area, end quote. That's Mashiri v. Ashcroft from 2004. In case you forgot. I forgot. Anyway, back to this decision. Here's your new rule. Quote, a single attempt to report an incident of harm by private actors to local police without further harm from the police themselves or evidence of their widespread collusion with alleged persecutors does not establish that the government as a whole is unable or unwilling to protect a respondent from persecution, end quote. In addition to finding different case law in your circuit, all I can say, I guess everyone, is remember that the Convention Against Torture inquiry is a bit different than the asylum analysis happening here, as is the low-level police officer precedent that has developed in the CAT context, including from Attorney General Barr himself. Careful, though, because the BIA actually finishes up with CAT, affirming the denial of that, too. But that was actually on relocation within India, and the BIA saw no error there. In no small part as well because, quote, the respondent has had no contact with his girlfriend in 5 years, and there is no reason to suspect that her family members would continue to target him if he were to return to India, end quote. Warning Mr. KSH that he now might get charged $998 per day, the BIA affirmed his order of removal. And that is a matter of KSH. We also have a matter of BSH this week, published by the BIA. This case is about Violence Against Women Act-based motions to reopen. That misnomer title of a statute because, of course, men are eligible too, including Mr. BSH, who is also from India, like the last respondent, and was ordered removed by an immigration judge. The BIA affirmed that in 2022. He remains in the U.S. and in 2023 filed a motion to reopen based on the fact that in the interim, he had filed a Form I-360 petition with USCIS based on abuse or extreme cruelty that he claims to have suffered from his U.S. citizen spouse. That's a VAWA petition. And all these things are permitted by immigration law. Relatedly, Mr. B.S.H. requested reopening and remand so he could pursue special VAWA cancellation of removal. VAWA, you see, can either be used to adjust status before USCIS, or, if in removal proceedings, adjust in removal proceedings if USCIS approves the I-360, or even without the I-360, obtain VAWA cancellation of removal and LPR status, provided that the immigration court itself believes the VAWA elements and a couple more met. You follow? USCIS made an initial prima facie eligibility finding on that I-360, by the way, as it is apt to do. Not always, but it does do it often. That's not conclusive of whether USCIS will ultimately grant the I-360, but certainly not a bad thing for Mr. B.S.H. And he supplemented his motion to reopen or remand with that prima facie determination. Yet still, the BIA denied the motion to reopen based on a finding that, quote, the respondent had not established prima facie eligibility for relief, end quote. Mr. B.S.H. then filed a motion to reconsider the motion to reopen denial, which the BIA is now considering and denied. Although it's not really a motion to reconsider because it doesn't identify errors of law made by the BIA in the motion to reopen denial, explains the BIA. This is more like a second motion to reopen. Or that is to say, I guess the legal arguments made were not agreed with by the BIA. The BIA does not believe the evidence here so compelling as to require a grant of that first motion to reopen, and notes that 8 CFR section 204.2 C6 II and IV makes clear that a USCIS prima facie determination doesn't really mean that much. It doesn't require the BIA to determine a prima facie case has been met. As to construing this motion as a motion to reopen, well, that makes it a second motion to reopen, and it's well beyond the 90 days required of most motions to reopen as well. But, quote, the general 90-day motion to reopen time limitation does not apply to motions to reopen filed to pursue relief under VAWA if the motion to reopen is filed within 1 year of the final order of removal, end quote. So there you go. And that's by statute. Quote, moreover, the Attorney General may, in the exercise of discretion, waive the 1-year time limitation in the case of a respondent who demonstrates extraordinary circumstances or extreme hardship to the respondent's child, end quote, by the same statute. And also, the one motion to reopen rule doesn't apply to VAWA-based motions. Quite the favorable framework for VAWA motions to reopen. Kind of. You can file a VAWA motion to reopen even if you've previously filed a different type of motion to reopen. But explains the BIA here, you don't get to file 2 VAWA-based motions to reopen based on the same facts. Analyzing a complex statutory framework to get there. Breaking new ground, too, on this, as according to the BIA, the only circuit to have addressed this is the Third Circuit in an unpublished decision. As such, explains the BIA, quote, the extraordinary circumstances or extreme hardship waiver for motions to reopen only applies to temporal limitations for filing a motion to reopen to apply for relief and not to the numerical limitations on such motions, end quote. Moreover, the second motion was not filed within 1 year of the removal order, explains the BIA. So despite all of the very important facts at issue in this case, this becomes a procedural, wonky, and very technical decision that limits VAWA-based motions to reopen. Deeming all of this not extraordinary enough to warrant sua sponte reopening, the BIA denied this second motion. And that is a matter of BSH. Not sure what to do when a client asks you about the EB-5 investor visa or how they can choose the right EB-5 project? That's where EB-5 support comes in. Founded and led by veteran immigration attorney Irina Rostova, EB-5 support helps investors navigate the entire process of EB-5 project selection and provides complimentary training for immigration attorneys who want to strengthen their EB-5 petition filing skills. Visit eb5support.com. That's eb-5support.com. Or click on the link in the show notes. Access their online attorney portal for training tools and practical resources, or schedule a time to speak with the team. All project guidance is provided by FINRA-registered financial professionals, so you and your clients can proceed with confidence. EB5 support, where immigration law meets investment expertise. Securities offered through Sequence Financial Specialists. Doing business as Invest America. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez Immigration Bonds take it from there. They help families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process, and they typically issue refunds within 1 to 2 weeks of receiving the I-391 bond cancellation notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your client stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40. And for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They got those too. They're family-owned and have been in business for 75 years. Gonzalez & Gonzalez Immigration Bonds. Efficient, supportive, and trusted. Visit immigrationbond.com, click on the link in the show notes, or call at 833-409-9200. Welcome back. With Kazarian v. Bondi, published by the Ninth Circuit on November 18th, 2025. This case is about physical stays of removal pending petition for review, and petition for review technicalities. It's a short one. And wouldn't you know it, Mr. Kazarian is repping himself. And he won his stay. Quote, "We grant the government's request for an expedited ruling on the motion to stay removal, and we grant the stay." End quote. LOL. And the panel is appointing an attorney for Mr. Kazarian. The dude's hitting it out of the park. The Ninth Circuit actually doesn't explain why on the stay. But as always, that comes down to the Nicken factors. The Ninth Circuit does, however, get into why it's denying Oyle's motion to summarily dismiss this petition for review. See, 8 U.S.C. Section 1252C requires that you submit a copy of the BIA's decision in your initial petition for review. The petition for review being a fairly short document that kicks off this entire appellate federal court litigation process. It's similar to what's required of Federal Rule of Appellate Procedure 3C1B and 15A2C, explains the Ninth Circuit. To paraphrase. But in enforcing that requirement, the Ninth Circuit applies, quote, "such requirements functionally, not inflexibly," end quote. Attaching the BIA decision is not a mandatory claims processing rule that a circuit must enforce if asserted, explains the Ninth Circuit. It's more like the federal rules of appellate procedure, which, in this case, are essentially all about fair notice to the opposing party. The court goes through quite a few cases where it and other circuits have excused strict compliance with similar appellate rules. So here, explains the court, we've got a pro se respondent who didn't attach a copy of the BIA decision and misstated the date of that final order by a month. But elsewhere in his papers, he was correct of the date of the BIA decision. For its part, quote, "the government had no trouble finding that ruling and filing it on the docket," end quote. After all, and this is just me, it would have known and been provided Mr. Kazarian's alien registration number. Pretty easy fix. Don't be such nerds, government, explains the Ninth Circuit. Let pro se Mr. Kazarian have his petition for review, which he gets. And he gets a stay. And he gets an attorney. Go, Mr. Kazarian. And that is Kazarian v. Bondi. Moving on to Luna Corona v. Bondi, published by the 10th Circuit on November 17th, 2025. This case is about good moral character. a showing required for many forms of relief, including non-LPR cancellation of removal, and which actually has a statutory definition at I&A Section 101F. In Mr. Luna Corona's case, his problem is because he got a fourth DUI in 2017, within the 10-year good moral character period required of non-LPR cancellation. Now, one DUI isn't a per se good moral character bar. Even Attorney General Barr's Castillo-Perez decision regards 2 DUIs. The problem for Mr. Luna Corona is that he had 3 other DUIs in 1995 and 1996. So quite a bit ago, and outside the good moral character period required of non-LPR cancellation. But at the IJ, this showed a, quote, continuation of multiple lapses in judgment, weighing heavily against a finding of good moral character, end quote. That is, the mistaken relapse 21 years after his last offense, for which he expressed remorse in court. The BIA agreed. Egregious, they noted, as did the 10th Circuit. The agency was permitted to consider those other 3 DUIs and their relationship to the 4th one, even though the first 3 occurred well beyond the 10-year good moral character period at issue in this case. The BIA properly focused on that 2017 DUI, explains the 10th Circuit, but there was nothing wrong with deeming it more negatively for good moral character as, quote, recidivist in nature, end quote. And as the IJ found, to only focus on the 2017 conviction, quote, would ignore the widely recognized relationship between recidivist behavior and one's moral character, end quote. Quoting 1895 Supreme Court precedent, the 10th Circuit explains that in the criminal context, quote, the punishment for the second offense is increased because by his persistence in the perpetration of crime, he has evinced a depravity which merits greater punishment. Repetition of the offense aggravates guilt, end quote. It's not an additional penalty for the same crime, it's about recognizing that the second crime is worse because of prior bad conduct, explains the 10th Circuit. As applied here, Mr. Luna Corona's, quote, moral character was bad in 2017 because he was unable to keep himself from repeating serious misconduct for which he had been convicted, end quote. It's not because he had demonstrated bad things in 95 and 96, explains the court. So there you go. Takeaway to me, at least, if you've got, say, a naturalization case with bad things outside the good moral character period and something bad within it, is to do everything you can to show that the recent bad thing is in no way, shape, or form a continuation, or in any way connected, really, to the older stuff. If you can. And that is Luna Corona v. Bondi. We conclude with McLean v. Bondi, published by the 5th Circuit on November 20th, 2025. This conviction is about aggravated felony crimes of violence, and it would appear that Mr. McLean represented himself before the 5th Circuit. Mr. McLean is a lawful permanent resident from Jamaica, but he was eventually convicted under 18 U.S.C. Section 115A1 for influencing a federal official by threat and was sentenced to 41 months in prison. If that's an aggravated felony, Mr. McLean is removable and ineligible for LPR cancellation of removal. It is, said the 5th Circuit, affirming the IJ and BIA. Recall, an immigration crime of violence is defined in I&A Section 111A43F, which in turn now references only 18 U.S.C. Section 16A to define it as, quote, an offense that has as an element the use, attempted use, or threatened use of physical force against the person or property of another, end quote. Got to also have a term of imprisonment of at least 1 year, which Mr. McLean has. This federal threat statute has a lot of text that I don't feel like reading to you. Suffice it to say, the 5th Circuit believes the statute divisible because there's a lot of separate subsections, and because the statute has different punishments for different conduct, presumably tethered to different subsections. Quote, these statutory alternatives carry punishments varying in severity and thereby create different offenses, end quote. That kind of stuff will generally make a statute divisible. As it's divisible, the modified categorical approach applies, meaning the 5th Circuit can look to a limited class of conviction documents to see what subsection Mr. McLean was actually convicted of. Implicit in all this, by the way, is an understanding that not all portions of Section 115A1 necessarily require the use, attempted use, or threatened use of physical force. Else it would be categorically a crime of violence, and we wouldn't care about divisibility. Do you care about divisibility? I care about divisibility. And you know what? If my grandma's still listening after all these years, I bet she cares about divisibility too. At the modified categorical approach stage, one such document you can review is the indictment, which accuses Mr. McLean with, quote, threatening to assault, end quote. That would be subparagraph A1B, explains the Fifth Circuit. The judgment and verdict supports this too, as does the 41-month sentence, explains the court. The analysis then comes down to assault. And remember, Mr. McLean didn't actually do it. He apparently threatened to do it. Nevertheless, the aggravated felony statute does expressly cover threats to commit violence. The Fifth Circuit appears to recognize that federal simple assault is not an aggravated felony because it states, quote, Mr. McLean was sentenced to 41 months of imprisonment, which means that Mr. McLean was not convicted of simple assault, since he could have been sentenced to no more than 1 year for that offense, end quote. So write that down. Seems like simple assault under federal law is not a crime of violence. But this is just me. Why couldn't he have been convicted of threatening simple assault? I'm not entirely following. But the Fifth Circuit believed his threatened assault, greater than simple assault, was sufficiently violent. To the extent the BIA held that this statute is indivisibly a crime of violence, that was wrong, but it was harmless error, explains the Fifth Circuit. Judge Richmond concurred for 21 pages to provide additional analysis. Not going to do it, but if you're curious, Judge Richmond does relay what Mr. McLean did. He, quote, threatened an immigration judge by threatening to F up the judge and to bash in her effing head, end quote. Real curse words said by Mr. McLean. So not great, to be avoided. And that is McLean v. Bondi. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.